caps. Now remember that there's a cap, there are caps to just how much candidates would spend in regards to the campaigns for the 2017 general election, and therefore that is also one of the discussions that we will be focusing on there. Also, on the second part of your screen is the beginning of the Deputy Chief Justice's position, the interviews that takes place today, starts today actually, and the candidate today is High Court Judge Abida Ali-Aroni, who is the first of 16 others to face the Judicial Service Commission. Now, Lady Justice Aroni was appointed to the High Court in 2009, and she also served as a Vice Chairperson of the Constitution of Kenya Review Commission. And something else about her is that she was previously found unfit to serve by the Judges and Magistrates Vetting Board, but was reinstated on appeal, and therefore she takes the stand today before the Judicial Service Commission. One other candidate who's going to be there is Agnes Murgo, who is the wife of the former Director of Public Prosecutions, Philip Murgo, and she was also appointed to the judiciary in December 2012, and she also sits in the Judiciary Performance Management and Measurement Steering Committee. All right, so those are the two candidates who will be going before the Judicial Service Commission today, and so we keep following up for you that those two top stories. So we want to go back to the Supreme Court and have a feel of what, of course, Justice Judge Abida Ali-Aroni has to say in regards to her interview for the position of Deputy Chief Justice.
Vice Chair as well, and thereafter, when the Chair Yash Palgai resigned from the process, I became the chair of the Constitution of Kenya Review Commission and actually steered the referendum, the first referendum in this country. I am certain that in my 30 years of service, I have gained adequate experience outside, within the judiciary system, and I believe that I have what it takes to join the team of leadership in the judiciary.
Thank you. Thank you very much, Judge. The rest of we will start with the panelists asking you questions. Be aware that we might interrupt you in the process of making your presentation. You are also free to seek clarification. This is a conversation. If you should feel whenever you're not clear, please do seek that clarification. I'll start off with the Attorney General.
Judge Aroni, I welcome you once again to this forum. I have a very few number of questions, and I'll request you to answer directly, then we'll finish quite early. Now, the first question relates to your own sense of the contribution you would like to make in the Supreme Court. Could you please summarize that for us?
Thank you, Honorable the Attorney General. To begin with, I would want to bring my experience outside and within the judiciary in terms of bringing in collegiality within the Supreme Court, fostering teamwork. Number two, I believe that having engaged in the constitutional review process, that I have first-hand information, first-hand feel of the aspiration and wishes of the people of Kenya, and I would be able to give that practical experience to the Supreme Court. Secondly, I believe I have acquired adequate legal knowledge that would enhance the judgment and decisions emanating from the Supreme Court.
Another question relates to our Constitution is now 5 years old. And you, as you've mentioned, you had something important to do with its promulgation and enactment. Do you feel that looking at the Supreme Court in particular, there is something we could have done differently about it that you would, if you were a member, to become a member of that court, you would want to urge that it should be reviewed?
What comes to mind is probably the number of the Supreme Court judges. I tend to feel that it would be wise to add to the numbers in the Supreme Court for the following reasons: that recusal is a little difficult given the numbers that we have. Number two, in the situation where a judge is absent, like in the current situation where there's a vacancy of 3 Supreme Court judges, the court is not functional. Number 3, probably the Constitution should have been more explicit in terms of the jurisdiction of the Supreme Court.
Us to make the Supreme Court purely a court of constitutional reference, or would you like us to expand its role as a general court of appeal, the ultimate court of appeal?
I think with a little clarification, the jurisdiction of the court is adequate in the sense that you do not want to clog the apex court with every appeal that emanates from the lower court. I think the jurisdiction as it is now is adequate with the clarity that I've talked about.
One last question relates to the gender equality, equity question that has bedeviled our constitution or law for the last 5 years. You know where we are now. The government has taken a bill to the House. That bill was lost. A bill was placed before Senate by a private senator. It was lost. And as we speak, we do not yet have an answer to how we will make sure that the House reflects the 2/3 gender principle. Do you have any advice from your very extensive experience with this, among other questions?
Thank you for the question. I think it is unfortunate that we do not have, this country rather does not have that political goodwill to implement that part of our constitution. Indeed, the issue of gender parity was key in constitutional reform. And on hindsight, I think the answer lies within Parliament, since the judiciary made a decision that has not been complied with. I think what should have happened actually is for steps to be taken to deal with legislature for failure to adhere to the 2/3 gender rule, because what there is now is that Parliament has declined or refused to adhere to the judgment of the Supreme Court. I think for the court, a decision was made and nothing more can be done towards that. What we require is really political goodwill.
A last question, half question. We are looking for a judge who has either one of these qualities in great measure. Either a great intellectual to drive the jurisprudence of the Supreme Court in new directions, or a great problem solver. Which of the two are you, or are you both?
I want to believe that I'm both. And let me tell you why I believe I'm both, and I will start with the one of being a problem solver. You are aware, Honorable the Attorney General, that when you and I sat in the Constitution of Kenya Review Commission, we encountered several problems within and outside the Commission. I think my experience at that level has given me the expertise to be able to solve and to know how to carry out the to solve problems that encounter and bedevil the judiciary. Number two, my long practice of the law gives me adequate intellectual capacity.
I thank you.
Thank you.
Thank you, Judge. Thank you, Commissioner AG. Commissioner Agenda.
Thank you, Chair. Judge, I will ask you a few questions. The first question relates to your sample writings submitted with the application, specifically the case that appears at page 33, JR number 86 of 209. This is a case that was filed before yourself. You determined with Justice Wendo.
Yes, I recall.
On the 11th of June 2010. And basically you are dealing with a motion that was filed by the Kenya National Commission on Human Rights.
It was filed by...
it was filed by...
the Honorable, the current President.
Now His Excellency,
Yes.
Uhuru Muigai Kenyatta.
Yes, that is right.
Seeking to quash his name from a report that had his name and that was prepared and commissioned by the Kenya National Commission on Human Rights.
Yes.
Then. You examined the grounds for granting or acceding to an application for judicial review, specifically certiorari, and then proceeded to make a number of remarks, the last page. And the ground, you then said that you would not quash the report in the relevant parts because the report had already been distributed to its consumers. And secondly, that this was a question of public interest. And then you proceeded to say that because you are maintaining the delicate balance, you would not quash the report and you'd use your discretion in favor of declining to quash the report. I just want to find out whether in your decision, did you not redefine the principles that ought to guide the court in allowing or declining an application for judicial review? And as you answer that question, Judge, is public interest an overriding factor where the requirements have been brought by a party to court to show that a violation has occurred? Does it matter that the violation is already out there? Now, when you look back to your decision, do you think that you add in your decision, just looking back and looking at the principles?
Thank you, Professor, for that question. I think that particular application was an important, dealt with an important and delicate matter in the history of our country. And apart from considering the interest of the litigant, we broadly considered the interest of the nation at large. We also considered the fact that this country at that particular moment was going through a very trying and the worst moment ever in the history of our country. Yes, we did note and we did admit in our decision that the rights of the applicant were actually violated in the sense that he was not accorded an opportunity to be heard. However, taking into account the circumstances prevailing then, we felt that we would use our discretion in favor of rejecting the removal or quashing of the extracts from that report that dealt with the president's
Judge,
issue.
fast forward.
Yes.
2010, we have a new constitution.
Yes.
We have a chapter 4 that is very vibrant on the Bill of Rights,
Yes.
Article 22, 23, sets out a progressive approach to interpretation of the Bill of Rights and of the Constitution. Would you, in the current circumstances, still find that a party such as this, His Excellency, then in 2009, would not be availed of these rights in the current dispensation, Judge?
I think we have now a robust Bill of Rights, Professor, but the circumstances prevailing in the country then is what really informed our decision vis-a-vis the rights of an individual.
Yes, but that is the point. You are balancing rights in personam against rights in rem, yes, looking at the wider public interest. But I'm saying, if this matter were before you now, would you arrive at the same position now, in the current dispensation? Judge, you want to be a Deputy Chief Justice. Would you arrive at the same position?
Yes, I would. Weighing the circumstances and the interest of the larger public, I would.
So are you that kind of judge then who would restrict the interpretation of the Constitution? Or how would you interpret the Constitution? Remember, you're one of the makers, the prime makers.
Yes, absolutely, Professor.
Yes.
I think Article 259 of the Constitution actually tells us how we should interpret the Constitution. It should be purposive, taking into account its principles and values. We should, uphold the rule of law. We should think of good governance. My interpretation of the Constitution would actually be progressive, purposive, and transformative.
Judge, let me ask you a small question as I move on.
Yes.
You had, in the commission where you sat with the AG, as you said, there were conflicts within the ranks of the commissioners. Was the influence political that time?
We were 27 of us.
Yes.
Each one of us came from a sector or represented the interests of different stakeholders. Many a times we had intellectual discourse and we would agree to disagree, and I think that having been a political process, that was expected.
So you are certainly part of the progressive half?
Yes, I want to believe.
So there was another half that was not progressive, Judge?
Not really progressive, but people had different interests. You are aware that our Constitution is a negotiated document, and that was really to be expected of a wonderful and beautiful Constitution like the one we have.
Would you favor, let me just move, would you favor an approach to the interpretation of the Constitution that grows the Constitution?
Yes, I would, especially in the area of fundamental freedoms and human rights.
So what do you understand by number one, what is the significance of the architecture and design of a constitution? And number two, and as you answer that, what do you understand by constitutional horticulture?
Constitution horticulture, that for me is a new terminology. Would you elaborate it a little?
Is the Constitution a document by itself, or is it a document that sets out beacons that must be interpreted